Good evening, everyone. So we'll be starting with SEBI regulation, SEBI prohibition on of insider trading, prohibition of insider trading regulation 2015. So I'll be sharing my screen and let me give you a brief that how we will be proceeding in this lecture. So we have a mix of questions. We'll try to revise through reading the important provisions. Also, we'll try to discuss by reading the comparative provisions, whichever are similar. So we'll try to cover all of them together so that it's easy to remember all of that. Then another thing is at the end of every chapter, I'll be discussing what all descriptive questions we can expect from all the chapters. So in this way, we are going to proceed in this session. So our topic is SEBI prohibition of insider trading regulations. And what all chapters are there in this? We have chapter 1, which is talking about preliminary, in which there are important definitions. Then we have chapter number 2, which talks about restriction on communication and trading by insiders. What all restrictions are placed, what there are provisions relating to trading plan, that all we are going to discuss. Then there is chapter number 2A, which talks about restriction on communication in relation to and trading by insiders in units of mutual funds. So these two chapters have quite similar provisions, and we will be trying to cover these two chapters through a comparative study. So that by remembering few of the regulations or understanding those regulations, we are able to cover two chapters at least. Then chapter number 3 is disclosure of trading by insiders. Chapter number 3A is information of violation of insider trading laws. Chapter number 3A is not titled. This is the brief title that we can understand. Information of violation of insider trading laws, information about the informant and the relevant provisions with respect to the claim of the reward. So all that is present in chapter number 3A. Then chapter number 4 talks about codes of fair disclosure and conduct. Chapter number 5 talks about miscellaneous. I'll be taking up all the queries at the end, because if I take up the queries, we'll have problem in the session. The session might get delayed, and with respect to the chapters or relevant provisions, I'll try to take up at that time. But let's keep up queries in the pauses that I'll be providing. So then I will be taking up all the queries. Then after the chapter number 5th, we have regulations, we have schedules. In the schedules, schedule A, B, B1 and C talks about the codes of conduct and the principles of fair disclosure. D and E are only talking about the forms. So D and E, you don't need to go through in detail. These are only the forms. Just remember what forms are there. Form for informant's voluntary information disclosure, and informant's claim reward form, and where it is to be submitted. So the name of the form has to be remembered. Rest schedule D and E, you don't have to go through. A, B, B1 and C will try to cover up in this session. So let's start. As I've said, we'll go through a mix of questions. So in the definition part, let's have a discussion, a little bit understanding of what do you think who is a compliance officer, and when the board of directors is not present, then who compliance officer will report to. Even if you don't know, just give it a guess. Answer is D, head of the organization. Compliance officer will report to the head of the organization. First of all, important definitions. Compliance officer is any senior officer. Then there are various characteristics, various qualifications of a compliance officer. He should be financially literate. He should be capable of appreciating the requirements for legal and regulatory compliance. So as the word compliance says, he is the person who has to ensure that whatever the regulation is saying, whatever, let's say, formats have been decided, whatever the code of conduct has been created, has been formed, that is to be complied with. He has to maintain that checks. that the compliance is being appreciated, is being followed by the various parties, by the head of organizations, key managerial personas, all those people. And he should also be responsible for compliance of policies, procedures, maintenance of records, monitoring adherence to the rules for the preservation of unpublished price sensitive information, monitoring of trades, and implementation of codes. So whatever anything has to be compliant with respect to the act, with respect to the regulation. That is the purpose of compliance officer. Then you have a small explanation based on the financially illiterate. It is a person who has the ability to read and understand the basic financial statements. These financial statements include balance sheet, profit loss account, and statement of cash flows. Moving to next question. The basic idea of the connected person is to talk about the access to unpublished price sensitive information. It can be through contractual relationship, it can be through the communication with company's officer, it can be through ownership of shares in the company, though this is not nowhere mentioned. So the idea is that if we are talking about a connected person, the key factor is that he is having access to unpublished price sensitive information. That is the key scenario, that is the key thing that is making a person a connected person. When we talk about connected person, any person who is or has during the past 6 months prior to the concerned act, he has been associated with a company directly or indirectly, or he has had frequent communication with its officers, he has been in any fiduciary or employment relationship by being director, officer, or an employee of the company. The idea is that he is having access to unpublished price sensitive information, or is reasonably expected to allow such access. And who all can be deemed to be the connected persons? These are all the people: the immediate relative of connected persons, banker of a company, intermediary as specified in section number 12, holding company or associate company, then investment company, trustee company, asset management company. You can have a question from this, that who among the following you think is not a connected person as per the SEBI prohibition of insider trading regulation. So, because of this, you will have to remember, at least go through it. You'll have to remember at least some of the key provisions, that who all can be connected persons. So here, investment company, trustee company, that whoever can be associated with the company, the member of board of trustees of a mutual fund, official of stock exchange, member of board of directors or employee of financial institution, then concern firm, trust, Hindu, HUF, Hindu Undivided Family Company or association, who may have 10% of the holding or interest, another official or employee of self-regulatory organization, or an which is recognized or authorized by board or any other area. So all these can be connected persons. Now, a very most lot of important question is, write a short note on connected person as per the SEBI prohibition of insider trading regulation. So this also you will have to remember, that what is a connected person, who all can be connected persons, and prepare a short note on. The question talks about not. Which of the following is not considered unpublished price sensitive information? The answer here is E, material events in accordance with listing agreement. This was earlier a part of unpublished price sensitive information, but now this is no longer a part of UPSI, unpublished price sensitive information. Now we have financial results, dividends, changes in capital structure, merger, demergers, and with effect from 2019, by 2018 amendment, this has been removed. Material events in accordance with listing agreement. We are just going through the definitions, through the questions. The next chapters will be covering through provision, understanding, and reading. This is given in your regulation 3 when we have started with the chapter number 2. Regulation 3 says insiders can communicate, no insider can actually communicate the unpublished price sensitive information except when it is required for legitimate purpose, for performance of duties or discharge of legal obligations. So this is the only scenario when the unpublished price sensitive information can be communicated by the insiders. So these were some of the most important definitions. Other than that, generally available information is another definition that you should go through. Then apart from that, the definition of securities, definition of takeover regulations have been mentioned in their respective acts. Just know where these are mentioned. Definition of promoter group, proposed to be listed, these are also there but very direct. The most important one were these three. Now we'll be moving to chapter number 2 and chapter number 2A, restriction on communication and trading by insiders or units of mutual funds. So we are saying the insider cannot communicate the unpublished price sensitive information. And even if that insider is in a company or is in working in a mutual fund or asset management company, they cannot communicate. This is what are the key things that are mentioned in your regulation 3, which is the communication or procurement of unpublished price sensitive information. So can it be communicated? Can it be procured? All the relevant provisions of regulation 3 are here. First, it says no insider shall communicate, no insider will allow access to, no insider will provide this unpublished price sensitive information except in furtherance of legitimate purposes, performance of duties, or discharge of legal obligations. Similarly, as a person, as an insider cannot communicate, neither can an outsider, neither can any person procure such information or cause the communication to be made to him. So in that scenario, we are moving to subregulation 2 that says no person will procure or cause the communication of unpublished price sensitive information except in the furtherance of the legitimate purposes, performance of duties, or discharge of legal obligations. Then the next thing that is mentioned with respect to this communication or procurement is the legitimate purpose, as we are saying in the furtherance of this legitimate purpose. So this legitimate purpose should also be defined. It should also be determined. This is the responsibility of board of directors. The board of directors of a listed company has to make a policy for the determination of legitimate purpose as part of codes of fair disclosure and conduct. What all purposes come under legitimate purposes, that has to be made by the board of directors. And any person now who is an insider who has possession of this unpublished price sensitive information is an insider. By any means he is having the possession of unpublished price sensitive information, he is an insider, and due notice is to be given to him that he has to maintain confidentiality and he has to comply with these regulations. That notice has to be provided to him whenever he comes in contact with this unpublished price sensitive information. But there is certain scenarios when this unpublished price sensitive information can be communicated. First of all, that is a possibility when there is an obligation to make an open offer. So when there are two types, first there is an obligation to make open offer, second there is not an obligation to make open offer. So when there is an obligation to make open offer, then board of directors of that listed company, they are of informed opinion that sharing of information is the best interest of the company. Then they can share this information. If they feel that it is very much in the interest of company, it is good for the company, they'll do that. Even if there is no obligation to make the open offer, these board of directors, if are of the informed opinion that sharing information is in the best interest of the company, they can do so. And also the unpublished price sensitive information in that case should be available at least 2 days prior to the proposed transaction, so that all the people could have access to it, to be adequate and fair to cover all the relevant and material facts. So whenever that transaction is to be done, whenever that unpublished price sensitive information is to be made, it should be, the transaction on that should be made available 2 days after. So that means after the proposed transaction, on the proposed transaction, before that, 2 trading days before that, the information should be made available so that it is adequate, it is fair enough for all the relevant parties, for all to know all the material facts, to understand all the important details. At the same time, for whoever is coming into contract with the company, whoever is coming into contract with that unpublished price sensitive information, the board of directors will require that those parties will execute agreements to contract confidentiality and non-closure obligations. So who all come in this? For example, let's say certain audit person comes here, or certain analyst who is trying to understand what will be good for the company, or any other research personnel through which the company is trying to understand some things, through which the company is trying to get some information or get some data by which they can take on a decision. So all those people have come into contract, who come into contact with that unpublished price sensitive information, and here the board of directors will require those parties to execute agreements that they will maintain the confidentiality and non-disclosure obligations. Parties will keep this information confidential and will not trade when they have access to that unpublished price sensitive information. Then point 5 and 6 says, talks about the structured digital database. Sub-regulation 5 and 6, it says that a structured digital database has to be maintained. The board of directors will ensure that this structured digital database is present. This and also in that structured digital database, information has to be entered. What all information has to be entered? That is, first of all, the nature of the unpublished price sensitive information. Second is about the name of the people who have this information, this unpublished price sensitive information. Third is the name of the people with whom this information has been shared, and the PAN number of all these names, PAN number of all these people, that has to be entered into the structured digital database. This database has to be maintained internally. It cannot be outsourced, because outsourcing it means the nature of unpublished price sensitive information is being shared with the outside people, which should not be done. So therefore, this information, this database is not to be outsourced and should be maintained internally. There should be proper checks to ensure that there is no tampering with the information, no tampering with this database. There should be time stamping, there should be audit trials to see whether this database can be breached or not. So all the checks should be there. Then this structured digital database should be maintained, should be preserved for a minimum period of 8 years related to a particular transaction. Or if the board of directors, if the company has information related to certain investigation, related to certain enforcement proceedings going on, so till the completion of those investigation or enforcement proceedings, this database has to be maintained. This is what is present in communication or procurement of unpublished price sensitive information. Now, as we said, that chapter number 2A also talks about the communication and procurement of unpublished price sensitive information, but related to the mutual funds. So we'll be covering that regulation along with this. This is what is the difference. First of all, that is regulation number 5C. You don't have to remember this, but I'm just giving you a comparative analysis so that you can remember easily. The first sub-regulation is the same. No insider shall communicate or allow access to unpublished price sensitive information except these 3 areas: furtherance of legitimate purpose, performance of duties, or discharge of legal obligation. Then second is same. First was saying no one can communicate. Second one was saying no one can procure or cause the communication. The third one is saying board of directors has to determine the legitimate purpose. But here it is talking about the asset management company with the approval of the trustees. So board of directors of asset management company with the approval of trustees has to make a policy for the determination of legitimate purpose. Then any person who is coming in possession has to maintain confidentiality in compliance with these regulations. That is same. How these can be communicated with respect to a company, we talked about 2 scenarios: open offer and without open offer. But here nothing is mentioned with respect to the communication and when it can be done. So in case of the mutual funds, this provision is not there. Then as we were saying, any party who is coming into contact with that company. Similarly, any party who is coming into contact with the asset management company, they have to contract the confidentiality and no non-disclosure obligations. So they have to make those agreements, they have to execute those agreements, and they will not trade in the unit of mutual funds, as they were not allowed to trade in the unit of securities. Here, these people will not trade in the unit of mutual funds. Similarly, structured digital database has to be maintained. Similarly, board of directors or head of organization will ensure that it is preserved for a minimum period of 8 years or till the completion of investigation or enforcement proceedings. So in this way, these two are related, and you can study them together. So is this clear? Let's take a pause. Is this clear here? Is it going fine? Is the pace fine for you all? Great. So let's move. Let's move further. Now we are moving to regulation 4, when we were talking about a company and what all was there with respect to in chapter number 2 about the unpublished price sensitive information. In the regulation 3, we said that communication and procurement, how it can be done. So here we talked about communication or procurement of unpublished price sensitive information, how that can be done, that is prohibited, in what circumstances that is to be done, and the maintenance of structured digital database. The next regulation, the next sub-regulation, it talks about if a person is in possession of unpublished price sensitive information, then whether they can trade, and in what, and what all obligations are present, what all compliances have to be followed so that they can trade even if they are in possession of unpublished price sensitive information. First of all, no insider, we know that no insider will be trading in securities that are listed or proposed to be listed when in possession of unpublished price sensitive information. However, even if a person trades, then there are certain circumstances through which the innocence can be proved. The person can prove the innocence. And also, another way of saying this is that if all these scenarios are met, a person can trade even if he's in possession of unpublished price sensitive information. So the first point is this transaction is an off market transaction between the insiders. Both the people who are transacting, first of all, it is off market. That means this transaction, whether this transaction was being made or not, it was actually not available to the common public. Both these people, both these insiders knew about what was there. Both of them were in possession of unpublished price sensitive information, and therefore this transaction was inter se, that means within two people who had this information, and both these parties have made conscious and informed decision. I lost my cursor, give me a second. Yeah. So both these parties have made the conscious and informed decision. And also, such off-market trade has to be reported to the company within 2 working days. If this trade is being conducted, then in that case, such trade has to be reported to the company within 2 working days. And then the company has to report it to the stock exchange within 2 trading days. This off-market trade is to be reported to the company within 2 working days by the insiders, and company has to report within 2 trading days from the receipt of information, from the receipt of this disclosure, or from becoming aware of such information. Even if the insiders didn't report it, the company got to know about it, then also they have to inform the stock exchange. Second thing, this transaction was carried out through block deal window mechanism between those persons. Now, what is this block deal window mechanism? Block deal window mechanism says that a window, this transaction is usually a huge transaction, a transaction of around 5 lakh shares and or a minimum amount of 5 crores. So if that much amount is involved, then in that case, the first 35 minutes of every trading window is blocked for these kind of transactions. For example, in case of if we talk about any Bombay Stock Exchange or something, so there from 9:15 to I think 9:50 or 9:05 to 9:40. So in this way, these in the morning AM. In this way, these 35 minutes are blocked for these kind of transactions. Therefore, the another circumstance is that these transactions were carried out through block deal window mechanism between those insiders, between those persons. Also, whatever transaction was being done, that was carried out pursuant to a statutory or regulatory obligation to carry out a bona fide transaction. This was a bona fide transaction done in good faith, and it was also in compliance. It was also as per a statutory or regulatory obligation. Okay, so it is carried pursuant to statutory regulatory obligation. Also, the transaction in question was pursuant to the exercise of stock option. So this is about the derivative, where we talk about options and futures. In options, we know that there is a predetermined price, there is a predetermined quantity to be transacted on a future date, and there is call option and put option that the person may choose to exercise that option. So if the transaction is being carried out pursuant to the exercise of stock option, that means the contract was already entered into uh, quite a time ago. So if that is there, so in that case, the transaction can be allowed even if the persons were in possession of unpublished price sensitive information. Another scenario is the trades were pursuant to a trading plan. Already a trading plan was submitted to the compliance officer, and pursuant to those trading plans, the trade was being done. And then if the people are non-individual insiders, if the we are talking about two insiders who are not individual, they are certain organizations, individuals who are in possession of unpublished price sensitive information are different from those taking trading decisions. So those individuals who are taking the trading decisions, they are different from the one who are in possession of unpublished price sensitive information, and there has been appropriate and adequate arrangements that these people are separate people. There was no communication of the information between them, and there is no evidence of this arrangement being breached. So then in that case, the trading can be done even in possession of unpublished price sensitive information. Then this SEBI regulation 2 says, if suppose a person is let's say he has been caught, or he has been blamed that he was in possession of unpublished price sensitive information, that means he is being found in violation of the regulation. Then who has the onus of establishing innocence? If they are talking about a connected person, then the onus is on the connected person. Other than that, the onus is on the board. All the standards and requirements for whatever we are discussing, the regulatory obligations, statutory obligations, that has to be specified by the board. This is what is regulation number 4. Coming to what one of you was saying, block deal window. Block deal window mechanism. Block deal window is for huge transactions. As I said, minimum 5 lakh shares के अराउंड होते हैं उसमें, और लगभग या फिर 5 करोड़ का ट्रांजैक्शन होता है. And mostly it is done in the initial hours of a trading window. So usually the time is 35 minutes. आई डोंट रिमेम्बर एग्जैक्टली 9:05 से 9:40 होता है या 9:15 से 9:50 तक. इस तरीके से 35 मिनट्स ब्लॉक किए होते हैं. उस दौरान those two people will enter into the transaction to transact that huge amount of shares or the huge amount of money that is involved. अब इसे block deal क्यों कहा जाता है? Because it is said usually that those amount of shares have been blocked, they are not available to the general public. Even if the settlement is done by the end of the day, even if the settlement is done by the clearing corporation in some hours, those much amount of shares have already been debited, and they will be credited as per whatever whatever was the transaction, whatever were the norms or key areas, key aspects of that transaction. Now moving to this regulation number 5D with respect to the mutual funds. Trading when in possession of unpublished price sensitive information. Again, no person, no insider can trade in the units of a scheme of mutual fund, which when in possession of unpublished price sensitive information, which may have material impact on the net asset value of a scheme or interest of unit holders. So there we used to say unpublished price sensitive information. Here we have specifically mentioned that any information which may have material impact on the net asset value of a scheme or impact on the interest of shareholders. However, the innocence can be proved that the transaction was an off-market intersay between the insiders. Both had made a conscious and informed decision. This was reported to the asset management company within 2 working days, and asset management company has reported to the stock exchange within 2 trading days. There is no block deal window mechanism with respect to the mutual funds or asset management company, and the further provisions are also a little bit different. That's why I have changed the color over here. This transaction in question was pursuant to statutory or regulatory obligation. So that is same. We talked about here that it should be pursuant to statutory or regulatory obligation. But in, even this includes the subscription or investment in mutual funds pursuant to mandatory requirement. And what is all this? So any person, let's say if there is a mutual fund scheme and there are board of directors or certain persons are there, they may need to invest. Let's move on. So we are saying, even if what was this mandatory requirement? Suppose there is a scheme, suppose there is a mutual fund scheme. So in that case, sometimes also that even what the in whatever amount is being collected in the mutual fund scheme, that is not being invested in wrong equity or debt. Therefore, there is a mandatory requirement. There is a mandatory requirement for all the people who are managing the scheme to invest a little bit of amount in the scheme, because अपना पैसा लगा होगा तो ज्यादा अच्छे से देखेंगे. That's one of the reasons. So the transaction in question was carried out pursuant to a statutory or regulatory obligation, including subscription or investment in mutual fund pursuant to mandatory requirement. Next, the transaction is triggered by systemic transactions, which these systemic transactions should be registered 2 months prior to such transaction. What all are systemic transactions? One most common is SIP, Systemic Investment Plan. It's like RD, recurring deposit, but in mutual funds. And every month, a certain amount is being deducted from your account. So if the transaction, the mutual fund, is triggered by systemic transaction, this transaction was registered 2 months prior to the transaction, then in that case, even if the person is in possession of unpublished price sensitive information, that trading is possible. Also, the transaction is triggered by irrevocable trading plan. Even it was here also the trading plan, which is approved by the compliance officer and disclosed on the stock exchange platform at least 60 days before the commencement of trades. So there is a cool off period of 60 days. The trading plan should be approved by the compliance officer and disclosed on stock exchange at least 60 days before the commencement. This trading plan should be of 6 months with no overlap. Please see, mutual funds, the time period for trading plan in mutual funds is different. अभी हम लोग चैप्टर नंबर 2 में फॉर कंपनीज देखेंगे, बट हियर इट इज डिफरेंट. रिमेंबर, इट शुड बी अप्रूव्ड बाय कंप्लायंस ऑफिसर, it should be disclosed at least 60 days before commencement of trades and should be running for 6 months, should be of 6 months. Then here also the owners of established innocence, it is either on the connected person or on the board. Then the last regulation with respect to the standards and requirements, it is not present over here. Now we'll be moving to the trading plan, which is regulation 5 in chapter number 2, जब हम company की बात कर रहे हैं. So first of all, there should be a trading plan which has to be formulated. This trading plan, what are the characteristics of this trading plan? This trading plan will not commence, shall not entail commencement of trading earlier than 6 months from public disclosure. So here a cool off period is of 6 months. In the previous mutual fund slide, we saw the cool off period to be 60 days. So remember this. Here the cool off period is 6 months. Also, this trading plan should not include any trading for a period between 20th trading day prior to the last day of any financial period, for which results are required to be announced by the issuer of securities, and second trading day after the disclosure of financial results. So what this is saying, that let's say a company, every quarterly financial results are declared by a company. So let's take a company, ABC Limited. This company is disclosing the financial results on 5th of any subsequent month. So when we talk about April to June quarter, on 5th of July, the financial results are declared. So 20 days prior to the 5th of July and also 2 days after the disclosure, second trading day after the disclosure, during this period, there should not be any trading. This is what should be present in that trading plan. This trading plan should be for a period of not less than 12 months. It should run for 12 months. This should not overlap with any period for which another trading plan is already in existence. So two trading plan cannot simultaneously work. There should be one trading plan for any particular period. It should not entail in trading in securities for market abuse. So it should not be like this, that a person has proposed that after 6 months, after the cool off period, I'll buy, let's say, 10,000 securities of some certain company, or 1 lakh securities. So the possible idea could be that there could be an involvement of market abuse. He's trying to just increase the demand so that the price could increase. He's planning to sell off the securities so that the price could decrease. So the market abuse should not be involved. It should sell out either. It should set out. So this is what should be mentioned in the trading plan. It should set out either the value of the trades to be effected or the number of securities to be traded, along with the nature of trade and the intervals or the dates on which such trades shall be effected. So as we talked about a holiday plan, what all of which hotel will you be staying, where you will be visiting, how much money will you be spending. Similarly, in a trading plan, what value of trades, suppose a person says on such and such date 1 lakh rupees I'll be spending, or this is the value of the trades, or the number of securities which he's planning to trade, along with the nature of the trade, like in debt, in bonds, in securities, in options, futures, derivatives, that should be mentioned, and the intervals at or the dates on which such trades shall be effected. That all should be mentioned in a trading plan. Once this trading plan has been submitted, the compliance officer will review the trading plan. The pre-clearance of the trades will not be required once the trading plan has been reviewed and the compliance officer has approved it. Then in that case, the person, if he wants to enter into the trades, he don't need to get pre-clearance because he has already gotten approval for the trading plan. The trading window norms and restrictions on contra trade shall not be applicable. However, if the trading plan has been approved, then in that case, still trading plan has particular things mentioned. Therefore, the trading window norms and whatever restrictions are there on the contra trade will not be applicable to this trading plan. This trading plan, once approved, is irrevocable and shall have to be mandatorily implemented. Now, why this is mandatory? Why can't the person not may choose not to execute? Why do you think this is there? It is irrevocable and shall have to be mandatorily implemented, because the person may have information of reducing the value of shares. Let's say he has 50,000 shares of a company. The present price is 1,000 rupees. And as per the trading plan, there is a mention that he is going to sell those securities on a particular date. But on that date, the price of those shares is rupees 500, and he might already have the information that the price is going to fall. So he may choose not to. That is why once a trading plan has been approved, it is irrevocable and will have to be mandatorily implemented by that insider. And upon approval, once that has been approved, the compliance officer will have to notify the stock exchange about a trading plan, about the proposed plan, about the proposed period for which it is going to function. Now, this trading plan was not mentioned in the mutual funds one. If an insider wants to trade in this unpublished price sensitive information, then yes, the trading plan is mandatory. This is for an insider. This is not for a normal person. For any person who wants to invest in securities and has access to the unpublished price sensitive information, he can only trade once he can give a trading plan. Otherwise, he will be held liable because he has traded while in possession of unpublished price sensitive information. This trading plan, this entire scenario and discussion is not there in mutual funds. In mutual funds, we have already talked here two sub-regulations about the trading plan, and that is all that is mentioned in the mutual fund chapter. Now, disclosure by certain persons, where we are talking about regulation 5E. This was all that was present with respect to the regulation, with respect to chapter number 2, regulation 3, 4, and 5. From 5A, आपका chapter number 2A start हो जाता है, where we are talking about mutual funds. So additional discussion that we are going to do is with respect to the mutual funds. That is why it is in orange, so that we can have color coding. और आप इससे भी देख सकते हो, we have moved to 5E. 5C, 5D we have discussed. We are now going to 5E, which is chapter number 2A. Okay, now moving to the mutual funds further regulations. Disclosure by certain persons. So what all has to be disclosed, what all needs to be disclosed. So here we are talking about disclosure by designated persons, by trustees, and by immediate relatives. This says the sub-regulation 1 says disclosure of detail of holding in units of mutual funds on an aggregated basis. So every person on an aggregated basis, how many units of the mutual funds that person is holding, that has to be disclosed by the asset management company on a specified date, and then later on quarterly to the stock exchange. That information has to be provided to the stock exchange.